In a preview of March Madness, it was a buzzer beater of an amendment, but the Michigan legislature enacted several changes to the Earned Sick Time Act that employers should know about. I'm Jen Muse, a partner in the Labor and Employment Group at Honigman, and I'm here with my partner Maja Zian to walk through 10 important changes coming out of that amendment. As everyone has heard for the last several months, the Earned Sick Time Act requires that most employers in Michigan allow employees to accrue 1 hour of paid sick time for every 30 hours worked, and employees are able to use up to 72 hours of accrued sick time per calendar year. For the vast majority of businesses, the spirit of that law stays the same.
But for small businesses, the law has changed. Our first change defines who a small business is, and under the amendment, a small business is a company with 10 or fewer employees. That's an important change because our second change builds onto that. Small businesses only have to provide up to 40 hours of paid sick leave in a year. There's no longer a requirement that small businesses offer additional unpaid time off under the statute. That doesn't mean that small businesses can't elect to offer additional time, but small businesses no longer are required to do so under the statute.
And in addition, change number 3 is that small businesses do not need to comply with the law until October 1st, 2025. So small businesses have a little more time to plan for compliance under the law. Our fourth change brings us to large businesses, so anyone with more than 10 employees. Large businesses have until March 23rd to announce your policy and put up your posters. Our fifth change is one that businesses and employment attorneys have been anxiously awaiting. There's now a cap on the carryover of accrued but unused leave from one calendar year to the next. For large businesses, that cap is 72 hours, and for small businesses, it's 40 hours. So if you had already prepared a policy under the prior law, you might want to consider adding that cap.
Coming in at number 6, we have more specifics about how front-loaded leave policies can comply with the Act. Now, a front-loaded leave policy is one where time off sufficient to meet the requirements of the law is granted on the first day of the benefit year. So employers can elect to front-load sufficient hours for their full-time employees, and that can be 72 hours for large companies or 40 hours for small businesses. For part-time employees, employers can front-load the amount of hours that they calculate a part-time employee will accrue during the year. However, employers must keep an eye on how much actual time the part-time employee works in case they need to earn more time. The benefit of front-loading is that employers don't have to allow employees to carry over the unused time from year to year. So if you front-load, you do not have to carry over from year to year. If you do not front-load, you may have to carry over from year to year.
Regardless of whether there's an accrual policy or a front-loaded policy, change number 7 is that newly hired employees have to wait until their 120th calendar day of employment to start using that accrued sick leave. And our 8th change is a clarifying point on how employers determine the amount to pay hourly employees for their sick time. The amendment makes clear that overtime pay, holiday pay, bonuses, commissions, supplemental pay, piece rate pay, tips, and gratuities are not included as part of the hourly wage rate for employees.
Change number 9 is a welcome one for most employers. It makes it clear that employees still have to follow employers' policies regarding requesting unforeseeable sick leave. Now, employers must give employees notice of these policies, and if there's changes to those policies, employers are required to give employees notice of that change within 5 days.
To wrap it up, change number 10 removes the private right of action that was originally included in the law. Employees can make a complaint to the Department of Labor and Economic Opportunity, but they are not able to bring a lawsuit regarding alleged violations of the Act. As a balance to this, however, an employer who fails to provide sick time to an employee in violation of the Act is subject to a civil fine of not more than 8 times the employee's normal hourly wage.
And those are our top 10 takeaways. But as with basketball, the steals aren't the only part of the game. If you have questions about the amendment, the Act, or how earned sick time impacts your business, we recommend you consult with your attorney on how best to implement these changes moving forward.